All right, everybody, welcome. Justice Watch Live, episode 13. And tonight we are going to be watching the sentencing of Robin Howington. Now, if you're not familiar with this case, it's a case out of Tennessee. It's about a mother who essentially left a firearm inside of a house while she went out to go smoke a cigarette, and her 3-year-old son picked up that firearm and shot her 5-year-old daughter. She attempted to cover this up, um, lied to the police, lied to investigators, made things up. Ultimately, it didn't go well for her at trial. She was not convicted of the essentially second degree. I can't say it on YouTube, um, but she was instead convicted of I believe it was involuntary, essentially the equivalent of involuntary manslaughter. Now, she was also convicted of child abuse, which in Tennessee, she can receive a sentence up to 25 years. So she was facing a minimum of 15 to 25 years coming into the sentencing hearing that we're going to be watching. Now, I had thought about why I had said last night we were going to be watching the deposition of Calvin Riley, but I decided, you know what, this was a case that happened this week, and I felt like this was something a little more relevant because it happened this week and I wanted to watch it. So I decided that this would be the case we would cover today. Switch gears a little bit and watch this sentencing hearing. So we are going to flip into the courtroom here. Again, it's an interactive show, so please let me know in the comments, thoughts, what you're thinking as we're going through this, as we're listening. We're going to get to hear from the defendant, I believe. I do believe we're also going to be hearing from the father of the daughter who got shot, who was actually accused, wrongfully accused, I might add, by this mother. Now, there was a backstory also to this. Is this woman was apparently sexually, whoops, I guess I can't say that word on YouTube, but she was SA'd by a police officer who was supposed to be overseeing her work release for her probation for other charges. This was in a couple of months before. This is why she ended up buying a gun. She had PTSD. So she had bought a gun because she was traumatized by that experience. It's also why she says she was intimidated into accusing other people of this crime. She said she was trying to cover it up because she didn't want her 3-year-old son to have the stigma of having killed his sister. So that's why she said she was trying to cover this thing up. And ultimately, that's why she said she had bought the firearm. So the defense was saying, you know, she's a woman, PTSD. She didn't mean for this to happen. She was traumatized and she didn't have the intent necessary to, you know, she wasn't abusing her kids or anything like that. There was no neglectful behavior. This was just a mistake. She alleged that, I guess, that there was someone who came to the house. She said it was for dropping off window tint. The prosecution said it was to sell her pills, and that was ultimately why the gun was out. Anyways, these are all things you're going to see talked about in the sentencing hearing today that came out in trial. How you doing, Cam? How you doing, Gabby? Nice to see you guys. Thank you for stopping in. I appreciate it. I was just going over the case that we're going to be watching tonight. I kind of switched gears and decided instead of the Calvin Riley deposition, we're going to be watching the sentencing hearing for Robin Howington that occurred earlier this week. So I'm not sure if you guys are familiar with that case. I'm sure you are, but it was not a trial we watched here. We were watching another trial when this was going on. Happy birthday, Cam! Happy birthday. How old are you turning? So big happy birthday to you. Awesome, awesome. My wife is about to have a birthday on Monday, so you guys are a couple of days apart. Is it Was it Saturday? Like, was it, or is it today, the 21st? Or I guess you guys would be one day apart if it's Sunday. I'm assuming it's Sunday. But happy birthday, 44. All right, so you're 2 years older than me. Nice, nice. Well, I hope you have a good time. Do something special for 44. That's a lucky one right there. 4-4. Today's Sunday. Okay, awesome, awesome. So yeah, you're one day away. My wife is celebrating her birthday tomorrow. So that's awesome. That is awesome. Well, thanks for stopping by to share the first hours of your birthday with us here while we're live watching this case. So I appreciate that. So we are going to go ahead and jump into the courtroom here with that introduction being given of the case, and let's start watching. Thank you, Gabby. I appreciate that. Appreciate that. I will let her know that she is sleeping. She worked all day today, and of course, with her being pregnant, it takes a lot out of her. So she was actually not feeling well because yesterday we decided to eat clams, and she sometimes has a reaction, and she did, and it was not a good one. I have not had a chance, Cam, to check out the 60-minute. I was actually out on the road all day today again. So tomorrow I am off. Tomorrow I am planning to get caught up and spend the day where I'm going to be digging into stuff. So I'm going to be looking into the 60-minute stuff that's on my list. Have it on my iPad over here. So I will be digging into that tomorrow and giving that a watch. Also, that's when I'm planning to hopefully finish the second episode of the Tyrone Tucker series I'm doing, which I've been promising for weeks now. So I'm hoping to have time to do that as well and get that out as well. So anyways, all right, so there we are, guys. So we are now in the courtroom here. Let me get this. I think I may have run it a little ahead. Let's see here. Let's run it back a little bit here. We're good. All right, there we are. So she's entering the courtroom now.
All right, let's go through. Ms. Howington was convicted in docket number 117659 in count 1 of the lesser included offense of reckless homicide. It's a Class D felony.
Essentially equivalent to like involuntary manslaughter.
Because I did file a sentencing memorandum, which I argue especially mitigated.
I understand, but I mean, she doesn't have any range enhancement convictions.
Mike, I didn't get a copy of that. I don't have a copy of Mr. Whalen's sentencing memorandum. Is there a way that I can get a copy from the court's file? I think it was filed yesterday.
I have my copy. I've already read it. All right, so she's 2 to 4 unless the court were to find she's an especially mitigated offender. In counts 2 and 3, she was charged and convicted of aggravated child neglect, a felony. Which count was the serious bodily injury count? Which count was the weapon count?
I believe 2 was the serious bodily injury, 3 was the weapon.
So interesting thing in this case, guys, is the charge. The more serious charge she was convicted of, because she was only convicted of reckless homicide and not the second degree. I can't say the word on YouTube. Because of that, the child neglect charges carry the weightier sentence. Where does this is taking place in Tennessee. and I believe it took place on Thursday this week. So this was this past weekend, Thursday. This is taking place in Tennessee, and she was originally charged. Essentially, the backstory, Gabby, the backstory to this case is she left a firearm out, and ultimately her 3-year-old son ended up using that firearm to um, to unfortunately kill his sister. He shot her. I guess she went out to smoke a cigarette. The firearm was in the apartment. Um, she also was moving her car. They had just gotten back from going to like a playground, and they were out playing. Apparently, the state said it was a drug dealer come over to deal her pills. She said she was coming over, or she claimed it was someone dropping off window tint for her window tinting business. But she had PTSD due to having been SA'd by a police officer who was overseeing her work release program, which had to do with drugs, possession of drugs. And um, as a result, she started carrying a firearm, or had bought a firearm to make herself feel more secured. And she apparently had that firearm out because this gentleman was coming in her house. She took the safety off and then apparently left it on the coffee table. She went outside to move her car, smoke a cigarette. As she's walking up the sidewalk, she hears the gun discharge, freaks out, goes inside, sees that her daughter is shot, calls 911, takes the gun, drops it outside in the bushes, and calls a friend and says, "Pick it up, please," because she doesn't want her son to get in trouble. So as a result, that's where she got some of these other charges you're going to hear her sentence for, which was destruction of evidence, obstruction of justice. She lied to the police. She falsely accused the father in the case. In her defense, claimed it was all due to her PTSD, due to her having been violated by this police officer. So, anyways, that's the backstory. This is happening down in Tennessee. She'd been out on bond for this case, I believe, occurred in 2018 or 19. We'll probably hear the date in here. But she was out on bond for a long time. Her parents helped her post bond, and then she was only when she was convicted, her bond was revoked. So she's only been in jail for a couple of weeks. You can see it's taken its toll. She's devastated. She wasn't expecting that she was going to be convicted. I think she really thought that she was going to be acquitted in this case based on the facts. But that's the background here. So let's jump in. Let's keep listening here on that, and give me a moment here. We'll get this fired back up.
All right, so she's 15 to 25 on each of those, unless the court were to find she was an especially mitigated offender. Where's the other? She was found guilty in count 5, tampering with evidence, a C felony, 3 to 6. Count 6, attempted tampering with evidence, D felony. Thank you. D felony, 2 to 4. Was there not a false report conviction as well? Yes, count 4 is false report. D felony, 2 to 4. All right. Does either side have, other than victim impact, additional testimony that the state or Ms. Hallington wishes for the court to consider before the imposition of judgment in this case?
Your Honor, no testimony from the state. I would like to introduce the PSI as Exhibit 1.
All right, Mark, the pre-sentence investigation report as Exhibit 1.
And then, Your Honor, Antoine Oliver has provided me with a few pictures of the victim that he was just also at the court to see before she died.
I mark those collectively as Exhibit 2. Mr. Whalen, any exhibits?
No, Your Honor.
All right, let me hear the state's position. Let's start first with enhancement factors the state believes are applicable to each of the various counts of conviction.
Yes, Your Honor. So the first one that we would ask the court to consider is that the defendant has a history of criminal convictions or criminal behavior. As noted,
Assuming you're urging that that applies to each of the 6 counts. Counts 2 and 3 merge. Which count is, I'm assuming the state is asking count 2 to be the one that stands, correct?
yes, Your Honor.
All right. So, previous history of criminal.
So just to clarify what the judge is talking about there, when he says they merged, she was convicted of 2 counts of child neglect. One was for the weapon, one was for basically the fact that this child died. So that's considered to be essentially by severe injury because death was resulted. So what happens is, and this happens commonly, they will charge. This is why you see a lot of people get confused because they see somebody charged with like 3 counts of manslaughter, all under different theories, right? And then there have, in this case, 2 counts of child neglect, all for the same offense, which was the 3-year-old getting a hold of a gun and shooting the child. But in this case, since they were convicted of all of them, they just merged together. Now the state is asking that there be an enhancement due to the fact that there was great bodily injury done, in this case, death of the girl. So as a result, what the judge was just clarifying here is that they're going to let the great bodily harm one basically be the one that stands, and then the third account, which is the in possession of a firearm, basically she neglectfully left the firearm out, that's going to merge inside of it. So that one wouldn't be the one that would get an enhancement. There would be an enhancement for the great bodily harm. So this is kind of a tactic that they use. I think it's a little bit ridiculous when they charge all of these for the same offense. I think the state should have to decide how it is, but the way the courts see it is the jury gets to decide, but then the jury convicts her of both. So I think that it's kind of confusing in a sense because, it almost essentially, in my opinion, contravenes double jeopardy because it says, well, the jury can decide this and this. And in this case, they said, well, both. She was reckless in not having secured the firearm. It resulted in the death of the child. And then there was child abuse or child neglect in the fact that the firearm was discharged and a great bodily harm was caused because she died, which I think is kind of like, man, I just think that it's one of these things that really doesn't make much sense. But I wanted to clarify that for those of you if you're wondering what you were just hearing. Anyways, let's get back to the hearing.
Convictions or behavior.
Yes, Your Honor.
All right, what's the next one?
That the victim of the offense was particularly vulnerable because of age. I think that probably only applies to count 1, being the reckless homicide.
What is the statutory subpart number for that?
That is 4.
Okay.
And then 6, that the personal injuries inflicted upon the victim were particularly great. I believe that would only apply to count 3. That would be the use of the deadly weapon.
Okay.
Factor 8, that the defendant before trial or sentencing failed to comply with the conditions of a sentence involving release into the community. And then 9, the defendant possessed or employed a firearm or other deadly weapon during the commission of the offense. That would only apply to 1, 2, and 5 also, because that was the tampering that involved the weapon, but especially to 1 and 2. we wouldn't apply to 3 with the deadly weapon.
So which tampering count was the weapon?
That was count 5, that she was actually, that was the full tampering, and then count 6 was the attempted tampering of the phone.
Okay.
And then finally, factor 10, that the defendant had no hesitation to committing a crime where the risk of human life was high.
So could you clarify? I think what the court said was counts 2 and 3 merged. So we're now talking about applying.
I have to enter separate judgments of conviction on each, but by operation of law, those judgments will merge. But they can argue the enhancement factors that they believe are applicable as to each count.
Was it 3 that were merging into 2? Is that
3 will merge into 2. All right, General, do you wish to be heard on any of the enhancement factors? Do you have any argument?
Yes, Your Honor. I did file a sentencing memorandum, so I won't go through them as extensively as I did in the sentencing memorandum. But just as it relates to that first factor, the previous history of criminal convictions or behavior, the defendant does have a couple of prior misdemeanor convictions, it looks like, for failure to appear, driving unrevoked, and a DUI. But really what I believe is most applicable here is the criminal behavior. We heard during the trial that the defendant was engaged in drug transactions prior to this, prior to the shooting of her daughter. She was selling pills to people. Mr. Key testified about that. He further testified that he actually met the defendant because she was selling pills to another individual that he knew. She, in her own interview, admitted to selling drugs. That was apparently her. That is why she claims she tried to destroy her phone, is because there were evidence of drug transactions within her phone. But not only that, Your Honor, I want the court to take notice of all of the other things that she did in this case in particular that she wasn't charged with, okay? And so specifically, again, if we're believing Ms. Howington's story that it was her 2-year-old that got the gun and shot the 5-year-old, having the gun where the 2-year-old could possess it in and of itself is neglectful. Obviously, she wasn't charged with that, but I do believe that it's something that the court can consider. Additionally, I think that it's very relevant that in this case, this defendant tried to literally frame the victim's father for first-degree murder. She went so far as to actually pick him out of a police photo lineup. That's how far she took it. I mean, by my count, she easily could have been charged with probably 10 or more reports of false reporting because she gave a different statement almost every time she opened her mouth. And so we would just ask the court to take notice of not only the criminal convictions that she has, but even the criminal behavior in this case alone that she wasn't charged with is very significant. As it relates to factor 4, that the victim was particularly vulnerable because of age, again, I believe that this applies to the homicide count. Here, the victim was 5 years old. Obviously, she was very vulnerable. She was very young. I mean, we heard the testimony. She was sitting on her couch watching cartoons when she was shot and killed. She actually had the remote in her hand. The bullet passed through her hand, passed through the remote, and went into her chest. And so we would ask the court to apply that particular enhancement factor to that count. The personal injuries inflicted upon the victim were particularly great. Again, this would only apply to count 3, the use of a deadly weapon. Obviously, we know that they were great. She lost her life. The defendant before trial or sentencing failed to comply with the conditions of a sentence involving release into the community. The defendant was on bond for several years in this case. The pre-sentence investigation reports that are part of the court's records indicate that she failed multiple drug screens up until, I believe, the middle of 2022, so almost 2 years that she was on pretrial. She kept failing drug screens for marijuana. In the pre-sentence investigation report, she admits that she kept smoking marijuana until 2022. Which would be a violation of her pretrial release. Possessed or employed a firearm. Again, I know that her story was that the 2-year-old possessed the firearm, but at the end of the day, this was her gun. She admitted to that. If it is true that she just left it around the house, it's still her responsibility. Also, it applies, I believe, to the tampering count, where it specifically involves her trying to conceal this gun in the bush outside the home after her daughter was shot. And then finally, as to the last one, again, that the defendant had no hesitation about committing a crime or the risk of human life was high.
How do I apply that in this case?
So I believe that that would go to the child neglect in this case. I mean, she had no hesitation whatsoever. She knew she had a gun in her house. She claims that she knew that somebody else had apparently put it back in her house. She didn't try and check to see where it was. She didn't try to make sure that it was safe. She didn't attempt to make sure that her children couldn't gain access to it. She did absolutely nothing as it relates specifically to the neglect, knowing that...
Not subsumed by the elements of the offense on the neglect?
Well, I don't know that it's fully subsumed within it. I guess it could be potentially in the deadly weapon. I'm not sure that. I mean, serious bodily injury doesn't mean that somebody's going to die. So I don't know that it's all the way consumed within the serious bodily injury count. But again, like I said, this was her gun. She apparently didn't know where it was for days, but a 2-year-old finds it in about 4 minutes. So we would ask the court to apply that factor as well. Do you want me to, are you just focusing on the enhancement factors
Right
for
now
now?
I'm just focusing on the enhancement factors. Mr. Whalen, address the enhancement factors as urged by the state, whether you agree with them or object to them. Once you have concluded doing that, address whatever mitigating factors you believe are applicable under TCA 40-35-113.
Yes, sir.
So let's discuss there what the state just said here. You know, one of the things that always gets me when you get these prosecutors up here, and it's like they try to rewrite reality, right? From look, I don't believe for 1 minute that this woman is some monstrous woman who's just intending to leave a firearm around her house so that she can have her kid shoot her other child. I mean, that's ridiculous. But if you listen to this prosecutor, it's like she didn't do anything to you know, she's leaving this firearm around the house, and you know, and she destroys her phone. And look, this is a woman that was afraid. You know, the thing about prosecutors is they forget about the humanity side of things, and they try to paint these people like this woman here who has gone through an amazing tragedy. Okay, I mean, like, do we not think she's devastated over this? Do we don't we don't think that there's an impact on her having lost a child to this? Every day of her life is going to be, it's like she was a devoted mother. There's no question about that she loved her 2 kids. She was a woman. And again, if you guys haven't followed this case, I followed it, Shadow followed it in the background. It's one that I want to air the trial eventually and watch it with everybody, because I didn't get to watch it at the time it was airing. But from what I've seen of it, this is a woman who had a lot of adversity in her life. A lot of bad stuff happened to her. She's not a bad person. She's not somebody who was setting out to intentionally do anything. So I don't think this jury is thinking to themselves when they came back with this verdict that she's going to get 25 years like the state's asking for in this case. It's crazy. I mean, remember, the offense they convicted her of gets a maximum, I believe it's 3 years in the state of Tennessee, but it's the child neglect that pops way up to 25 years. So, you know, the way these prosecutors, I just see this all the time. It's like, you know, you got to wonder, are these prosecutors perfect people? Are they, you know, it's as if they live in a different world than what we live in, and they come back and they look at a case and they don't try to view it in real world terms. And that's what I see a lot when we're covering these cases. And it's like the Nikolai Mew case. You break down that for 1/24th of a second, and you start breaking that down in frames of 1/24th of a second. And yeah, you could see this thing as this a much different act than what it was when you roll the tape in its entirety and you see that band of children, or that band of kids attacking him and verbally going after him and getting people on the riverbank to come over to him. But it's like that's not the reality when you're looking at 1/24th of a second. And that's what they're doing here. They're looking back at this Monday morning, quarterbacking it and saying, oh, we had a loss of life of a child, so therefore we've got to try to, we're going to reanalyze everything that's going on here, and we're going to look at this and try to vilify this woman and make her look like she's this absolutely terrible individual. She's a person who a tragedy happened, and she reacts, and she isn't perfect in her reaction. She lies, she panics, she does some stupid things, and these people want to lock her up for 25 years, and on top of that, she's also living with the fact that she lost her daughter. I can't even imagine the amount of grief she's feeling and will feel for the rest of her life, and then she's got to go serve whatever this judge decides to give her. So we hope the judge might have a little compassion for her. But just unbelievable. Anyways, let's get back to watching.
As to the history of convictions or behavior, there's the most minimum of misdemeanor history in this case. And on top of that, it was this failure to appear in Sullivan County where she was sentenced to do community service and gets raped by the officer who's managing the community service program 18 months before this incident, which, as I will argue later, contributed to the PTSD that she was suffering at the time this happened. And the abuse of Mr. Oliver, who apparently is not going to be standing here today saying anything either.
Your Honor, he is going to give a victim impact statement. He's asked the state to read it, just to let the court know.
He has the right in the statute to give a victim impact statement.
I understand that. He will not be giving the victim impact statement. He'll have them read it. He didn't testify at trial, though some of what he said was used. So
focus on the enhancement and the mitigating factors.
That is one of what we'll also be arguing as mitigation. The state wants to talk about uncharged drug transactions. The court might recall Ms. Howington's interrogation and how many times Riddle told her, we ain't the drug police, we don't care about drug cases, this ain't about drugs, this is about a 5-year-old child who's dead. Then we introduce it at trial, now we argue it at sentencing, even though she wasn't charged. So I would suggest that none of that should apply, Judge. Rumors of conduct should not be used for sentencing purposes in a case like this or any other case. But there are constitutional guidelines for a reason. In the plea agreement form, which is produced by the court, and in those cubby holes over there, it talks about, you understand that if you enter this plea, these charges could be used if you are convicted of something in the future. The idea of vulnerability of the child, that is one of the elements in the child neglect. So
I think they're only urging that as to count 1, the reckless homicide.
And I don't know how you use that in what the jury had an opportunity to convict her of, felony first-degree murder. Did not, and found reckless homicide. And so a reckless act is not something that should be considered when we talk about the age of the victim. What they said was, that the state said, no one's going to tell you that she intended to do this.
Well, what the case law says interpreting that particular factor is that there has to be the vulnerability of the victim has to be in some way causally connected. In other words, it was easier for the defendant to commit the crime because of the particular vulnerability of the victim, be it age or some form of infirmity.
And I would suggest that either under a negligence theory or reckless she was convicted of, there's nothing that would suggest this crime was committed in order to take advantage of the young age of the individual. So I don't think that applies, Judge. And again, injuries inflicted upon the victim were particularly great. Again, she was charged with felony first-degree murder, was not convicted of that. And so we're back to the reckless homicide, and.
Well, death's an element of reckless homicide.
Right. And so I don't see.
But I think the argument is that the injuries as to count 2, the aggravated child neglect count, that the statute requires that they prove serious bodily injury. In this instance, it went beyond that; it was death.
Well, and what we have is a case in which count 1 was homicide, a felony murder in perpetration of aggravated child neglect. So when the jury finds finds her not guilty of that charge, finds her guilty of reckless homicide and aggravated child neglect, it puts you in a different situation, because technically that's the definition of felony murder. So we're saying, okay, there was a reckless homicide and the underlying felony of the felony murder. And so I don't know how you separate those now at this point for sentence enhancement. And again, I think more so, not all cases are the same. This is a case where they're saying and said to the jury, we're not telling you she intended any of this to happen. And then again, almost like with the age of the victim, if she didn't intend any of it to happen, then how do we hold her responsible anymore for particularly great injury that she didn't intend to happen than we did for age? This was a horrendous family tragedy, which has not been made any better for anybody because of this trial and its conclusion. It's still a tragedy. And it's as much a tragedy for Ms. Howington as it is for anybody else.
Unfortunately, Mr. Whalen, most of what this court deals with on a daily basis is tragedies.
I don't disagree, Judge, but we rarely see them at this level. I mean, in this circumstance. I don't know how pretrial release got to be a sentence of release to the community.
I'm not very concerned about that.
But I have to say, because the state has brought it out, if you look at the entire report, which is attached, I believe, to their memorandum, shows that she had 3 April, May, and June dirty drug screens, which for a regular user of marijuana.
So, couple things I want to address here. What this attorney's talking about, what he is in a veiled kind of way discussing is, I think, what's going to be coming out on appeal, and that is the contradictory nature of this verdict. What he's saying is she was charged with felony murder, okay, and the way that works is in perpetration of a felony, a child died. That felony was aggravated child neglect. So the jury goes, and essentially the way, and again, this sounds like this is going to be a very big appeal issue, because what you essentially have is you have this jury convicting her of reckless homicide. In other words, it was a reckless situation. It was an accident that occurred. She accidentally leaves that gun out, and her child picks it up, and boom. But so by them finding that it was reckless, okay, it was reckless homicide, thereby acquitting her of the felony murder. In other words, what this guy's saying is they essentially had to acquit her of the aggravated child neglect, because it can't be aggravated child neglect. Aggravated child neglect is essentially child neglect that has grievous bodily injury. In this case, it was death, and in this case, there was a firearm was used. So what he's saying is how do you have a conviction of reckless homicide, which is essentially acquitting her of the felony murder, and then you turn around and they find her guilty of aggravated child neglect? By definition, by them convicting on those 2 aggravated child neglects, which was basically their route to get to felony murder. In other words, even if they don't think it was that she intended to harm her child in that way, or intentionally did anything with intent, with an intention to harm her child, they'd say, well, the gun, because the gun was left out, that would get them there. That would be the felony child neglect by her not securing the firearm. So essentially what he's saying here is the state now is trying to backdoor this thing because she gets found essentially not guilty of felony murder and is guilty of reckless homicide, which is punishable by only 3 years. And now the state's going, okay, well, we want to now get an enhancement on the aggravated child neglect based on the fact that this child died as a result of the circumstances. And the aggravated child neglect was based on the fact that the child was grievously injured by the neglectful behavior of this parent. So the idea here of what this attorney is saying is we have a contradictory verdict. Normally what would happen is this would have been rectified potentially by saying, well, I got to dismiss I'm going to have to say, and there is a route to doing this, and this appeals court can do it, is saying, well, the jury didn't understand this, but by finding her essentially not guilty of felony murder, they essentially unknowingly acquitted her of those other 2 charges because there isn't a route to get there to explain how they could have found her guilty of reckless homicide and then still convicted her both of those. The jury in this case, again, as a lot of juries don't, as a lot of times happens with juries in complicated cases where they're trying to understand the law and how to apply these laws, didn't quite understand that. And it's probably going to have to go back to looking at what the jury instructions were in this case and how the judge instructed the jury on how to come to a verdict. But as I'm sure this judge is going to figure out a way, and as we get into the sentencing portion here, to justify that and say, well, there is an explanation because the child died. And that's where this defense attorney is saying, Your Honor, that doesn't make sense. I know you want to ignore it. I know the state wants to ignore it. This is a family tragedy. As he said, that hasn't been helped by charging the mom. Is society better locking this mother up? She's already endured the loss of her child, so let's throw her in prison for what was an accident. I mean, does that make sense? 25 years? I don't think it does. And then we're going to call that child neglect. I mean, I guess not having secured that firearm or whatever the circumstances were, I guess is considered neglectful. But should it be punishable for the rest of your life in prison? Should it be punishable for 20 years in prison? I don't think it should be. I mean, I think we're in the neighborhood of a couple of years if we, just to simply say, hey, listen, you should have secured this. But again, there's no greater punishment that comes. Now, if this had been a situation where this mother had decided to, shoot her child in the leg and it bled out just because, she, did something wrong, that would be, I think, the way this law and the way the aggravated child neglect law is meant to be applied. This is another situation where the prosecuting attorney's office takes a tragedy and attempts to apply it after the fact, much like the Crumley prosecutors did when they decide, well, we want to go and prosecute, these parents because of the outcome. So we're going to figure out how we can just throw the book at them because, it's such a horrifying result of what happened here. But does that really serve the greater good? I mean, there is that idea. What does this do in terms of, making the community better or applying the law in this way? And to me, I think, this is a woman that I don't think it serves any purpose to me. But that's just my opinion. Anyways, let's get back to watching this.
Marijuana would not necessarily be unaccounted. You would almost expect that to be true for 90 days. After that, she'd been clean every time they tested her. She did everything pretrial asked her to do, made every appointment, kept up with payments, kept up with payments for GPS. I would suggest she was very successful in that particular endeavor. So for those reasons, we don't believe that any of the enhancements should apply in this case.
What mitigating factors under the statute do you urge?
I would, number 3, that substantial grounds exist tending to excuse or justify the defendant's criminal conduct, though failing to establish a defense. And again, Ms. Howington, at this point, no one can deny that she was diagnosed and treated for PTSD based on the rape at the hands of a police officer in Sullivan County and the physical abuse and mental abuse and emotional abuse of Mr. Oliver, including 3 days before this event when he shows up and then wants to talk about how he's the victim of that. But she had to get a gun to say, get off my property. He wouldn't go away. He's upset because she got her boyfriend there. So there's that. Then we have that she comes home after taking the kids across town to their favorite park, comes home in the dark, is at the house, a shot rings out, which, as you recall, during voir dire, we talked to lots of potential jurors who had people with PTSD in their life, who said that that shot going off would be a trigger. Then saying that it's your daughter has been killed and your son has pulled the trigger. All those things contribute to the mental state she is in when she is then taken to the hospital, not allowed to go with her daughter, but taken to the hospital, told her daughter is dead, and within an hour is in the interview room with Mr. Riddle. And when she tells them she's nervous because she was raped by a cop, he loses his mind and yells and screams at her and questions her humanity. At that point, that interview was over. She is fully triggered at this point, and by an officer who's sitting there talking to the woman whose child is dead and yelling and screaming at her over and over again. And the state then stands up again and says, well, you should consider as an enhancement factor uncharged conduct in that she tried to frame Antoine Oliver. The testimony is crystal clear. I asked them, who raised Antoine Oliver as a suspect first? They did. Then you asked her, do you believe he would do that? And she said, no, I guarantee you he didn't do it. And then they stayed on it until she says, I can't take it. You're right. I can't take it anymore. You're right. She did not try to frame Antoine Oliver. They did. And then you have the nerve to come in here and tell the jury different and then stand up at sentencing and say different. That is not true. It has never been true. She agreed with them after denying it and telling them she guaranteed them he did not do it. A woman who, in her mental condition, is in the interview room from about 11 p.m. until 4 a.m. with them. She did not get the 48 to 72 hours a police officer would have gotten to be able to get their thoughts together. She went from the hospital being told your daughter's dead to being interviewed. Further, we would say that number 7 applies, that she was motivated by a desire to provide necessity for her family or herself. And what she said from the beginning was that she puts that gun outside, and within minutes after all that is texting her friend to go pick up the gun that Gavin killed Destiny. So she's telling that story from the beginning. She explains to them why, when she tells them that story, that she didn't tell them in the beginning say that to the police was because she didn't want Gavin to live with the fact that he had accidentally killed his sister. There's been no proof that that's not true, that wasn't her motivation. And she was telling people she told Mr. Key from the beginning. And Mr. Key, again, has raised, I should have raised that on the enhancements, that he said he met her through somebody else who Ms. Howington sold pills to. Your Honor may recall that the Friday before that trial, he testified he knew her, he was introduced to her to do odd jobs around the house. And he did odd jobs around the house. And he got some pills. And then he comes to trial, so she says, how do you know him? Oh, as a drug dealer. That's not what he testified to at that hearing the Friday before the trial. That was not the first thought of Ms. Howington. It was about that she paid him to do odd jobs around the house. But that part of the story that she was trying to protect Gavin was consistent if it wasn't the first statement she gave them, because she was still trying to protect Gavin at that point. She gives them the statement that an unknown black man fired a shot from the door. Clearly, she did not do that for racial reasons. Both of the fathers of both of her children, of those young children, are black men. She didn't have anything against black men. She's just trying to protect Gavin and keep them off of Gavin. Is that necessarily a rational concern? It might be if you got PTSD and you've just been through what she's been through. It would tend to make you irrational. The third mitigator we would submit is number 8, that she was suffering from a mental or physical condition that significantly reduced her culpability for the offense. And that, again, is just the same thing that I've argued before, is on the PTSD and what's happened that night in her home, and then being taken to the police department and abused by Detective Riddle in a way I've never seen happen before in any interview, or to that level. The last mitigator is that number 11, although guilty of the crime, she committed the offense under such unusual circumstances that it's unlikely that a sustained intent to violate the law motivated the conduct. Unfortunately, when we look at what the medical examiner said, once that shot was fired, within 90 seconds at the most, that child, Destiny, was dead. The responding officer said, he tried to save her life, but by the time he got there, Destiny would have been dead. And he finally admitted that, yes, clinically, she was deceased. Clinically and in every other way by that moment. So it's a horrible thing, but for him, he did the best he could under the circumstances. So we would suggest, Judge, that there was, again, because of the way it's charged, even as a negligent act, it is hard to understand how you could negligently intend to violate the law in this matter, or that intent motivated the criminal conduct. It was this idea that she had a gun in the house and didn't know where it was. Had it not been for Mr. Oliver coming over and being upset that a boyfriend was there and taking the gun away from her, throwing it on the ground, and he testified, Callie picked it up, put it back together. She testified, Callie said, "What do I do with this?" She said, "Put it away." When they asked her in the police department, "Where do you keep your gun?" she told them where she kept her gun. She wasn't thinking, she hadn't had that 48 to 72 hours, that she didn't know where Callie put the gun. It was just a horrible circumstance on that particular day that led that gun to be where Gavin could find it. So we would say that if the court finds that she has no prior felony convictions, and I think that's clear, and that if the court finds that there are no enhancement factors and finds that there is a mitigating factor, then we would ask the court to sentence her as a specially mitigated offender. It would reduce the sentence on that charge to 13.5, I think, and the lesser rate means nothing, but it's a constricted sentence under the statute that's still 85%. So that's what we would be asking the court to do.
All right. The state has, in their sentencing memorandum, urged that under TCA 4035-115 that consecutive sentencing should be considered by the court. As each of you are familiar and well versed in, that in this state, in order for this court to impose a consecutive sentence unless otherwise provided by law, that she has to meet one of the criteria within that statute. Which do you say are applicable?
So, Your Honor, if you don't mind, just because I did not get a chance to respond to Mr. Whalen's.
You don't need to. Let's go to consecutive sentencing.
Okay. The ones that we specifically say are, one, that the defendant is a professional criminal who has knowingly devoted life to criminal acts as a major source of livelihood, and 4, that the defendant is a dangerous offender whose behavior indicates little or no regard for human life and no hesitation about committing a crime. Oh, I'm sorry. I said 1. I meant to say 2 and 4. Okay. Yeah. I apologize, Your Honor. I meant to say 2 and 4, not 1 and 4. So 2 being that the defendant is an offender whose record of criminal activity is extensive, and 4 being that the defendant is a dangerous offender whose behavior indicates little or no regard for human life and no hesitation about committing a crime when the risk to human life is high. And so, Your Honor, I do just want to kind of touch on a few things that Mr. Whalen just said. First of all, when we're talking about Ms. Howington and all these problems that she is suffering, the only evidence that was introduced regarding her PTSD or anything else like that came straight from her mouth. We did not.
True. That's misstating the record. They went through her purse and asked her about every medication she was on, and it was all PTSD, psych meds.
Newsflash to both of you. I tried the case, and I'm very familiar with what the facts are. You don't need to address the enhancement factors. Make your argument on consecutive sentencing.
When we look at number 2, that the defendant is an offender whose record of criminal activity is extensive, there's case law that makes it very clear that that does not necessarily mean a defendant who has multiple prior convictions. The court can look to the criminal conduct in the case at hand when determining whether or not a defendant is someone who has a record or an extensive record of criminal activity. Again, Your Honor, when we look at this case, the defense wants to keep arguing this is a tragedy, this is an accident, all these things. I don't dispute the fact this is 100% a tragedy. The problem is the tragedy was caused by the defendant and no one else. They want to point the blame at the child's father, who was nowhere near when the shooting occurred. They want to point the blame at saying that she was raped, by the way, which, again, I'm not saying that she wasn't. I'm not saying that she's a victim. What I'm saying is that in that particular case, Your Honor, the person who she said raped her was convicted of false reports. That is all we know. And certainly, Mr. Whalen would not allow the state to get up here and call somebody who was convicted of false reports a rapist. So that's all I'll say about that. Again, every single thing that happened in this case was her fault and her fault alone. Not only did she, according to her own statement, leave a loaded and cocked firearm within reach of a 2-year-old for days. That was her testimony. Her testimony was that this happened days before, that Callie supposedly went inside, put it away. She never checked where he put it. She never did anything. But then a 2-year-old, again, according to her statement, a 2-year-old has the ability to find it within about 3 minutes. He was pretty small. The court saw pictures, measurements of him. He didn't take stools around everywhere and climb up like she initially claimed. That was not the case. This thing was sitting out where it was easily accessible to him. This tragedy was 100% preventable, and the person that should have and could have prevented it is the defendant. She's not the victim here. The victim is the 5-year-old child that died, okay? So not only do we have the issue of this defendant being just careless and negligent as far as it goes with the gun, it's her actions after her daughter is shot that we urge the court to consider.
All right. Thank you.
And also, well, I guess that kind of goes in with the behavior indicates little or no regard for human life. A lot of that does. There are just a couple of other things that I do want to bring to the court's attention. Sorry. Again, we talk about the detectives beating up on her and everything like that. Your Honor, we all saw the video. The detectives absolutely did say they suggested Antoine first, okay? No doubt about that. The fact of the matter is, she knew good and well that Antoine had nothing to do with it. She could have persisted in saying no. That's all she had to do. She didn't have to continue to make up story after story after story. She didn't have to pick him out of a lineup. Mr. Oliver could not go to his own daughter's funeral because she had literally framed him for murder. When she took that stand, and I asked her that, her words verbatim were, Antoine didn't matter. That's what she said. Those were her words. I didn't put those words in her mouth. The detectives didn't put the words in her mouth. Those were her words on the stand. She did not care about him whatsoever. She didn't care. She didn't care about anybody in this case but herself. This was not about protecting 2-year-old Gavin. All of her lies were not about protecting Gavin. If she wanted to protect her son, she should have done that before he got a hold of her gun. So for all those reasons, Your Honor, in this case, we are asking the court to not only give the maximum sentences, but we are asking the court to order consecutive sentences based on those factors.
All right, let me hear from, is Mr. Oliver going to be the only victim impact statement?
Yes.
Let me hear that.
I do have some argument on consecutive.
Folks, the case law on this is very clear. And, I can do this for show, but I don't operate that way. It would never stand up on appeal in this court's humble judgment to sentence her consecutively. Let me hear from Mr. Oliver.
So Your Honor, he does have a victim impact statement that I'm going to read.
You're going to read it?
I'm going to read it on his
Okay.
Your Honor, I have a lot to say. I beg the court in diligence while I speak my piece because I've found over the years I'm not always afforded an opportunity to say stuff, and I must speak the truth. So this time, if for no other reason...
All right, so I want to stop there just to, before we ride into the victim impact statements. This is the father of the daughter. This man was accused of, or was accused by the defendant, wrongfully accused, in the state's words, framed for the crime, even though it was suggested by the detectives. Now, what this prosecutor's asking this judge to do, and what the judge said is, I'm not going to do that stuff. I'm not going to go and, like he just implied, he literally just, I like what the judge did there, because he basically said, listen, you know better, Miss Prosecutor, case law doesn't allow me to sentence consecutive. What the state is basically saying is they wanted the judge to go against case law, risk getting reversed on appeal, and have all 6 of these charges stacked consecutively. In other words, 25 for the aggravated child abuse. There's like 3 years. You're going to hear, we're here to different sentences, but essentially it would have come up to something around probably like 35 years in prison, almost the rest of her life in prison. And that's what the state's asking here. And you can almost, like I said, it's like they believe she was lying to protect herself, is what they're saying. And maybe she was. I mean, she was afraid. Her daughter got shot by her 3-year-old son. I mean, many people might be afraid in that circumstance. Many people might be concerned that they're going to get charged with something. And it's it's just like, again, it's like these prosecutors don't live in reality. They don't live in a reality-based place here where they're able to look and look at this thing and say, hey, this is a mom, this is a woman who was abused by the dad who you're seeing a victim impact statement from. She was violated by a police officer who was supposed to be overseeing her work release. The prosecutor pretty much discredited this. Now, I guarantee if that prosecutor was standing up here prosecuting a case for SA, she would be the first one to say we don't discredit a victim. But she's doing it here because it's convenient to her case. Because she's upset because this little girl was shot, and she believes, I guess, this mother, even though the jury didn't find that and didn't say that this mom did anything intentional and didn't commit first-degree felony, this prosecutor wants to stand up here and act like that's exactly what she got convicted of. And they're upset. They lost because they got themselves all worked up on emotion and anger, and we're upset over the 5-year-old dying, and upset over the fact that this mother lied. And again, apparently, I guess she's got some history there, probably with this prosecuting attorney's office having prosecuted her for other stuff. But to me, I think this is just, it shows, to me, it highlights a problem that we see a lot with prosecutors. They just don't, it seems, live in the same reality as everybody, as the people in the communities they're living in. It's like they operate in this external reality where they can't put themselves in and see circumstances and say, hey, things happen sometimes. But it's not always, the remedy is not always lock them up and throw away the key. And that's not always the remedy to the case. I mean, I understand it gets this woman and it gets her colleague. That's how they get the headlines. That's how they look like they're hard on crime. That's how they move up the political spectrum, showing that they're getting the convictions and locking people up. But that is one of the major problems in this country that we have, is we think the remedy for every problem is let's go lock everybody up, but that isn't necessarily the answer. It's not the answer to every problem. It's not the answer to every crime. Sometimes, yes, we want to punish, but at the same point too, we need to make sure that it makes sense. And in this case, I don't think it does. I mean, this is a woman who has this gun not because she wants to go out and kill somebody, but because she's afraid for her own life. She's afraid for her own safety because of the harm done to her by others. And you'd expect a prosecutor who has experience would show a little empathy for someone like that, but apparently not. Anyways, let's listen to this victim impact statement. Again, this is the man who is the father of the victim, I believe either ex-husband or ex-boyfriend. I'm not sure if they were ever married, but they're no longer together. And allegedly he was abusive to her. So this is her abuser in her sentencing hearing by the prosecutor in the state being brought in to read this statement. I mean, wow. Well, let's take a listen.
Reason than that, this court is going to hear the truth. I can't speak for anybody else, but I can tell you, if nobody else says it, I'm going to speak the truth, and this is it. Who knew that on September the 12th of 2019, that would be the last time that I got to see and spend time with my beautiful daughter, Destiny Jariah Oliver. She was absolutely the true definition of a daddy's girl. All Destiny ever wanted was to be with her daddy. Robin was jealous of our relationship, and she couldn't stand it. Destiny was the best daughter that any father could have asked for. I was so excited to surprise my daughter and to have the opportunity to pick her up from school that Thursday. Her face always lit up when I arrived to get her, and that day was no different. I always made plans of doing a lot of fun activities with her after school when I was able to get her. That day was different, though. It was very special. First, we went and got food from her favorite place, Chick-fil-A. Next, we continued our journey to National Fitness Center off Walbrook Drive in Knoxville. She went swimming, and she also did rock climbing that day. After a few hours, we left there and went to Brewster's to get ice cream. We ordered our ice cream and sat on the bench and enjoyed it together. As we sat there, I looked at my baby girl. I knew something wasn't right, but I couldn't put my finger on it. We talked about what she wanted to be for Halloween and what she wanted for her 6th birthday that was coming up that was less than 4 weeks away. But that moment was extra special as I stared into my daughter's eyes, not knowing that it would be the last time of having her in my possession. My last time being able to do anything with my precious daughter. We left West Knoxville and headed back over towards Fountain City so that I could take her home. As I got closer to Broadway, Robin called and asked if I could go to Party City to get a costume for Destiny for school. We had a few words. At that point, I knew that she was trying to cause problems. I hung up on her and went to Party City and let Destiny pick out her costume for school. Shortly after that, we arrived at her house. I got Destiny out of my vehicle, and as I approached the door of the house, Robin came out of the house and instantly started attacking me. I tried to deflect the blows that she was throwing. Then her boyfriend came outside, and I asked him to get her, but he refused. He then closed the door so that the kids couldn't see what was going on. Robin and I had a few more words before she went back inside and came back out with a gun. I asked her, "What are you going to do with that?" And she said she was going to shoot me. I noticed that she really didn't know what she was doing, and the first chance that I got, I grabbed the gun and disarmed her. I took the clip and made sure that no round was in the chamber. I was going to throw the gun on the roof of the house so that she couldn't get to it, but ended up tossing the clip in one direction and the gun in the opposite direction so that they would be far apart from each other. Robin then ran back into the house to get something else. I didn't know what she was doing, so I got back in my vehicle. She came back out with her cell phone, threatening to call the police on me. She asked her boyfriend, did he find the firearm, and he said yes. She then proceeded to try to open the door of my vehicle, yelling and screaming at me. I rolled my window down and told her boyfriend that he needed to get away from her because she's trouble, and that he had no clue what that she was a psychopath, and then I left. To this very day, I wish that I never had taken Destiny back over there that Thursday night. Robin then called me early Saturday morning as if nothing happened Thursday night. I did get to speak to my daughter on the phone, but it was not long at all. Robin took the phone from her and proceeded to talk as if nothing happened. I told her she was crazy, and then I hung up on her. I didn't speak to her anymore that Saturday. I didn't find out about Destiny's death until the next day, which was Sunday, and was told that she had passed away. The grandmother called and told me that Destiny was dead. I couldn't believe what I was being told. It was the worst day of my life. My family and I went straight to the Knoxville Police Department to find out what happened to Destiny. I wanted to make sure that I wasn't being lied to. I spoke with an officer. He asked me a few questions about my whereabouts Saturday night, and shortly after that, he said that I was the one who had killed my daughter, which was false. I wasn't even in the city when my daughter had died. I was told to come back the following day to speak with detectives. I came back in the next day, which was Monday, and I was interrogated for quite some time. The detectives wanted my cell phone so that they could search it and invade my privacy. I was humiliated, yelled at by these detectives, and then accused of killing my own daughter in cold blood. I couldn't believe what I was going through. Here I am, a grieving father that had just lost his daughter and being blamed for killing her. I was threatened multiple times that if I didn't give them my cell phone, that they would hold me and lock me up. I ended up giving it to them and still haven't received it back to this day. 2 days after the interrogation, they got a search warrant and kicked in my door and raided my residence. They told my landlord that I was wanted for murder and that I was never coming back because I was going down for killing Destiny. My landlord thought very highly of me until that day, and he wanted me out of the house immediately. Unfortunately, I wasn't there at the time of the raid, and that was the same time as my daughter's funeral. I wasn't able to attend the funeral because of this situation. They really ruined my entire life while I was still trying to process the death of my baby girl. I was unable to get all of my belongings from the house. Some items were stolen, some items were also left behind. I ended up spending a lot of unnecessary funds on attorney's fees because I was being accused when I was completely innocent and had nothing to do with any of it. Your Honor, this woman has caused my family, friends, and I so much pain and heartache. She has been a very violent individual. In the past, she tried to have my ex-girlfriend kidnapped and admitted that to me. My ex-girlfriend had to purchase a gun for protection because of Robin. Robin has vandalized multiple vehicles of mine. She's vandalized one of my other friends' vehicles that was parked outside of my place.
Ron, this goes beyond the scope.
I can consider it only for the purposes of victim impact statement. It's not evidence that will be within the record.
I've lost thousands and thousands of dollars that I've invested over the years because of this lowlife. She has harassed me by following me and popping up at my house at all times and stalked me for years because I didn't want to be with her and she couldn't stand seeing me in a relationship with someone else. She broke into my house and stole a lot of valuable items previously. She has lied and made false reports numerous times. One time she even called the police and told them that I was kidnapping our daughter one night. She had the whole entire police department at my house for nothing. She's threatened to have my mother's brains blown out. She's also said that she knew people that didn't have a problem with killing a kid. She even called DCS on my son's mom for no reason, trying to get her children taken away from her. This woman should have been taken off the streets years ago and put away behind bars, but she lies and manipulates the system and always manages to slip away without getting in trouble. This woman is a real piece of work, as you can all see by now. This isn't even a fraction of all that she's put me through. Robin used my daughter to get at me any way that she could. Sometimes she would go weeks without letting me see and talk to Destiny. There were numerous times that Destiny cried and cried because she didn't want to go back home with her mother. As of October of 2017, Robin had lost custody of both Destiny and Gavin. They awarded custody to Robin's mother. I knew nothing about this. No one contacted me about this situation at all. I never knew anything about these court dates. I didn't find this out until March of 2019. I went to pay child support and happened to ask for any and all documentation filed on Destiny because I was seeking custody of my daughter. They printed out numerous documents, and this is how all of this was revealed to me. After 2 years of me not knowing any of this, it was finally revealed because of my actions. I found out that Robin had a real bad drug habit and she'd lost custody of Destiny because she kept failing drug screens while she was pregnant with Gavin. The court awarded the grandmother custody without my knowledge. Even when Destiny died, the grandmother was there supervising the kids, was supposed to be there supervising the kids because she was appointed to do so. Robin wasn't allowed to have the children unsupervised. The grandmother violated a court order and failed us all, as well as the state, because they shouldn't have been awarded custody without each of the fathers being evaluated and looked at as having custody of their own children. If the state would have done their job correctly, my daughter would have been in better care and would still be alive today. Robin is negligent. She cared nothing about her children. She made up multiple lies years back and had me arrested. I had to enter a best interest plea just to keep from going to jail. I provided video evidence of her actions. She has been the aggressor this entire time, telling me that she's going to have me put in prison somehow, some way. Even in this case, she told law enforcement that I was the one that had killed my daughter. I am the victim here, and she needs to be put away forever. She lied historically and used the state of Tennessee as a weapon against me and everybody else, and attempted to do the same thing in this case. In the past, I've shown videos that I've taken surreptitiously to have to prove that this country isn't premised on proving our innocence. I've had to prove my innocence all because she is a woman, but in reality, she is a lowlife and cared nothing about Destiny or her other children. The only thing she cares about is herself. She lied repeatedly in this case. She's culpable in it. Robin is the reason that my daughter is dead. It is my desire to see her rot in prison. I want her to be there for the rest of her life if possible. If not, I beg the court to give her the maximum sentence possible. She deserves to die in prison. She is responsible for the death of one of the weakest in society, a small innocent child who was defenseless and had no say in what her mother did and put her through. Yet she did it over and over, and the state turned a blind eye to it. She deserves to die in a prison cell somewhere. That's what I'm asking, to put her in prison for as long as you possibly can. She's a liar, she's a manipulator, she's responsible for the death of our daughter. Robin is a poor excuse for a human being. She again is responsible for the death of a child, someone who didn't have any say-so in what was going on. She manipulated the courts in this country and punked everyone here for years, making up lies about me. Again, I've had to enter a best interest plea, and my attorneys have had to show videos that I've taken to prove my innocence. I've had to prove my own innocence, and that's not how this country was founded. That's not what our Constitution is premised upon. But I've had to do that because she is a master liar and manipulator and used this court and every court in this country to her benefit to get even with me and to accomplish her will, all because I didn't want to be with her. Even during the course of this case, she's lied through her teeth and said it was me that was responsible for this horrific tragedy. I ask this court to give her the maximum sentence possible. It is my desire to see her spend the rest of her life in a prison cell. Because of Robin, I have no daughter now. At a minimum, I desire for her to be put away forever. I'm asking for consecutive sentences, maximums on every charge ran consecutively so that she never comes out of prison. She is a poor excuse for a human being. That is what prisons are made for, is to keep people like her who victimize anybody that they can for their own benefit. I'm asking you to keep her in there forever. If you can give her a life sentence, Your Honor, that still wouldn't be enough. It's my desire to see her go away for the rest of her life. It's my desire to see her die in prison. You know what else she did? She blamed it on her 2-year-old son for the death of our daughter. She is a despicable human being. Not only did she victimize and cause the death of our daughter, she further victimized her own 2-year-old child by blaming him for his sister's death. Your Honor, I am begging you to give her the longest and maximum sentence that you possibly can string together.
All right, thank you. Ms. Hallington, this is your opportunity to speak before the court makes certain findings and pronounces judgment. In this case, you're not required to, but this is your opportunity if you wish to. All right. The court is tasked pursuant to TCA 40-35-114 and TCA 40-35-113 to first find whether enhancement and mitigating factors, which are confined to these two statutes are applicable. The state urges a number of different enhancement factors. There's a couple that I'm going to rely upon because I think they're just glaringly obvious in this case. And while I could find perhaps other enhancement factors, I don't think there's any point in muddying the record up on appeal with going into those, because there's no specific set of enhancement factors. There's no calculus or graph that the court has to follow as far as I can only go up so far if I find 1 versus finding 5. That's not what the law says. Ms. Hallington,
This is a strange case. This is one of the more unusual cases among the hundreds that I've tried as a lawyer or as a judge. But there are a couple of things in this case that are just glaringly obvious. I agree with what General Good just said a few minutes ago. You are not the victim in this case. You have a previous history of criminal convictions or criminal behavior. What you had before the night that this tragedy occurred was not very significant, although you were engaged in the trafficking of illicit narcotics, and the court can consider that. But I really don't know how you could have made this much worse than what you did that night. Within literally minutes of when your daughter had been shot and killed, you were attempting to hide the firearm that was used to kill her. You're not concerned, you weren't then, you're not now. You're not concerned with trying to protect Gavin. You're concerned with trying to protect Gavin's mother. And you have been, you were that night, and I will believe that from this point forward. I don't know how you could interpret this evidence any other way. You have a previous history of criminal conviction,
Now, see, I don't necessarily agree with the judge here. I mean, I think that there is a natural predisposition that you're going to protect yourself in a situation like that. But I don't believe that she wasn't trying. I don't believe that she wasn't not trying to protect this young man. She was trying to protect all of them. She was freaking out. She didn't want her son to, I mean, she doesn't know what's going to happen. But there is one thing here that we should say to her, and that every person out there watching this should understand. The one mistake she made was she should have requested an attorney. She shouldn't have done anything. She certainly shouldn't have tried to hide the gun. But once she did that, she shouldn't have sat down with the police. She should have requested an attorney, explained to the attorney what happened, and then let the attorney speak for her. If she does that, she mitigates all these other problems that you're about to hear about. She mitigates all these other issues that comes up. And perhaps she avoids some of these other convictions that she was convicted on. Now, clearly this judge wants to enhance this. Clearly this judge feels like public sentiment is she needs to be convicted and sent away for a long time. Obviously, the history between her and this gentleman, who he says she was a horrible person to him. She says he was a horrible person to her. Obviously she wins the sweepstakes in terms of who's going to get punished, because she ended up being the one that caught the conviction here. For essentially, like I said, I mean, she didn't secure a firearm. This is somewhat similar to the Crumley case, but this is actually more in line with what the Crumleys, with a scenario for what the law of reckless homicide in this case would be created for, because she left the gun out. For the 5-year or the 3-year-old gets it, doesn't understand what he's doing with it, picks it up, boom, fires it, daughter dies. But how you can get intentional crimes out of this, how you can look at this as child neglect, I don't know. I think it's a stretch. How you're going to get to aggravating factors because she might have been involved in selling drugs previously, or whatever it was she was distributing. I think it was some pills or something. I mean, that was a separate crime. But I guess, I don't know. Maybe the statute doesn't provide it has to be related. But I think it's a stretch here. And as I said, I think she has the ultimate punishment. She has to walk around knowing her daughter has been killed. And that's, I can't even imagine. Anyways, let's get back here to listening to the sentence here. We're just about to the end.
behavior. You tried to hide the gun that was used to kill your daughter while her body was still warm. When you were taken to UT Hospital to be checked for shock before you spoke with law enforcement, You attempted to solicit another person to take your cell phone so that it couldn't be looked at, and then you tried to destroy the cell phone. Within seconds, if not minutes, of when your daughter was shot and killed, you're calling 911 and making up a story about how it all happened. And repetitively, I quit counting at about 20. Repetitively throughout hours worth of police interviews, not just that night, but on other occasions as well, you made up story after story after story. And this court can consider every bit of that as criminal conduct. So you clearly have a previous history of criminal convictions or criminal behavior which enhances your sentence in this case. As to count 2, the aggravated child neglect where there was serious bodily injury, count enhancement factor number 9 applies as well. A firearm and your handling of that firearm is the reason that your daughter is not here now. It's not because Antoine Oliver showed up 2 days earlier. It strains the bounds of credulity to believe that your boyfriend just laid that gun down where a small toddler could just walk in within 2 or 3 minutes after you and your children arrived home, found the gun, pointed it at your daughter, and pulled the trigger, when that gun had been in that same place for 24 to 36 hours and nobody saw it. I will never believe that. And I don't think you were honest with the jury about how that happened. But the simple fact remains that however he found it, you were responsible for that gun. What I believe happened, if in fact it was your child that had the gun, when the bullet was fired that killed your daughter, there was a man that came in. And I don't know if it really was somebody to collect window tint payments, or if it was a pill deal, but somebody came in. It was a strange man in your house, and I believe you had that gun out for protection. I believe you had a round chambered and the safety off, and that gun was left there, and when you stepped out to smoke, the tragedy occurred. But that's on you and nobody else. So I place great significance on the 2 enhancement factors that I found. Your history as well as the firearm use in this case. As stated previously, the mitigating factors, this was an unusual case. There are unusual circumstances, but I don't place much weight on that as far as mitigating your punishment. So if you would, please, ma'am, stand up. Ms. Allington, in docket number 117659, based upon the jury's verdict of guilt, finding you guilty in count 1 of the lesser included offense of reckless homicide, you were found guilty of that offense and sentenced to a term of 3 years to serve within the Tennessee Department of Correction as a range 1 offender. In count 2, based upon the jury's verdict of guilt, finding you guilty of aggravated child neglect, you were found guilty of that offense and sentenced to a term of 22 years to serve within the Tennessee Department of Correction as a range 1 offender. In count 4, based upon the jury's verdict of guilt, finding you guilty of false report, a Class D felony, you were found guilty of that offense and sentenced to a term of 3 years to serve within the Tennessee Department of Correction as a range 1 offender. In count 5, based upon the jury's verdict of guilt, finding you guilty of tampering with evidence, a Class C felony, you were found guilty of that offense and sentenced to a term of 5 years to serve within the Tennessee Department of Correction as a range 1 offender. And finally, in count 6, based upon the jury's verdict of guilt, finding you guilty of attempted tampering with evidence, a Class D felony, you were sentenced to a term of 3 years to serve within the Tennessee Department of Correction as a range 1 offender. These sentences will be served concurrently, one with the other, for a total aggregate sentence of 22 years to serve within the Tennessee Department of Correction. And as your attorney has pointed out, the service rate is at 85%. I wish we weren't here. I know you wish you weren't here. Mr. Oliver wishes that we weren't here, but you're the one responsible. That'll be the judgment of the court. Good luck to you. When do we need to set this for motion for new trial?
We need a transcript. I suspect that's going to take.
That's going to take a while. She's really backed up. I mean, why don't we set this out?
All right, so there you have it, guys. 22 years in prison. The state was asking the judge to do 36 years in prison, even though the statute didn't provide that they could go consecutive. But if they made those sentences consecutive, they were asking for 36 years in this case. At 85%, she'll serve 17 years, about 7 months. That's the minimum she'll serve. So we're just call it 18 years. So we're in 2024. We're talking about 2042 before she gets out. She'll be in prison for the next 18 years. So, is that justice? In my opinion, no. The judge could have done, because of the aggravated child abuse, he could have found anywhere from 15 to 25. So he knocked off 3 years. He didn't go to the top end. He didn't max her out. 25 was the maximum sentence she could have gotten. But he could have gone as little as 15, and then everything would have run consecutive or concurrent with these sentences. But he chose not to do that. So, I just, I don't agree with the judge in this case in terms of how he chose to view these things, in terms of finding the enhancement factors. I mean, he stretched, and because really, when I look at this case and I look at how she was acting, she was afraid that they might find evidence of drug dealing on her phone, I think, is what came out at trial. So she was trying to, I think what she was really concerned with, honestly, the state said it was drug dealing. She said she was worried that they were going to find the text message because she had texted someone to come pick that phone up. Again, I think it all just kind of flows from there. She freaks out. She makes a bad decision. She pitches the gun out into the bush, calls somebody to try to, hey, come get this gun. Help me out with this. Because it's, a situation where she's afraid. I mean, I think anybody would be afraid in that instance. And she's trying to protect her son. And we end up here in an incredibly tragic and horrifying situation. I don't know. It's terrible. How you doing, that one girl? Thanks for stopping in. I think you missed the sentencing, but if you go back, you're going to be able to watch and see what the sentence was. That's what we're discussing here. Appreciate you stopping in, but yeah, it's just like I said, it's an incredibly tragic situation. Do I think the community was served? Do I think the greater good was served by locking this woman up for 22 years? No way. Do I think that's what the jury thought was going to happen? No, probably not. But I guess we'll see what happens. I'm doing well. Thank you, that one girl. Doing well. Doing well. Little disturbed by the sentence that we just watched. I think it's a disappointing outcome, but like I said, I think even the 15-year sentence would have been too much in this case. I mean, I believe me, I'm not discrediting the fact the 5-year-old died, but I'm just saying the circumstances, the uniqueness of this case, the backstory, the trauma this woman experienced. This was not a scenario where this child was like, something where an intentional act occurred. This, to me, justice gets served with a 3-year sentence in this case. A 3-year sentence makes more sense to me because, she served some time, but this isn't the end of her life. Now it's the end of her life, and you send her into prison, and what does she have left in 18 years? Then you might say, well, that little girl lost her. Well, that was her little girl. But the greater good wasn't served here, in my opinion. Just a real shame. So, anyways, guys, that is the show tonight. I appreciate everybody who stopped in, everybody who chatted. Head over to Kofi.com / Justice is a Process. Get registered today. Follow. You can follow the site, and you will be able to get notifications when we're going live, when we're dropping videos, updates on cases we're following. The Karen Reed case essentially is going to start this coming week. We've got the Trump case going on. We're going to be putting updates up over there on that. But it's, going to be the spot for you to go over and find out all things Justice is a Process. You can also go over to buymeacoffee.com as well. Same deal over there. Whichever one gets more popular and has more followers, we will decide which one will become the official site. But first thing I need to do is get people over there to follow. It's also a place you can show your support by buying us a cup of coffee, joining a membership, and all of that. Chad Daybell trial. Yes, you're right. That one, girl. The Chad Daybell trial is up too. Yes, you're correct on that. And there's lots of interesting stuff coming out over there. I've got to get caught up on that. I saw there was more jailhouse call was released where he's, I guess, was talking to Lori and saying we're getting searched. They've had, I guess there was footage of him in the back of a police car that was coming out. Again, that case, we know what the outcome of that case will be. He's going to be convicted. If he isn't convicted, I'll be surprised. And I understand. We're supposed to be giving him the presumption of innocence, but in a case like that, we know there's just Lori Vallow has already been convicted. He's going to be convicted. I guess the interesting part of a case like that is going to be what's his defense, and I guess we'll find that out. But yes, the Daybell case is going on. I believe there's another case out there that's going on. There's several interesting ones. It's great. It's like prime time right now. Yes, because she does have another trial coming up, doesn't she? Yes, in Maricopa County. Any chance you could get caught as a juror in that case? That would be interesting. But I mean, it's like in cases like that, it's a foregone conclusion of what's going to happen because we know these, there's an overwhelming amount of evidence. Well, that would be interesting. Well, if you do that one, girl, then you got to come on and talk to us. I mean, not, don't let us know you're a juror, and then afterwards you can come on and talk to us about your experience in the case. That would be pretty interesting to be able to talk to a juror or have a juror that's on there. Not during the case. We don't want to violate any issues, but be able to talk to someone who sat on the jury and gives us the insight as to what happens. Yeah, I know that's the difficult part of being a juror and serving on that. You're right. That would be a difficult situation, but it is unfortunately part of the process. But remember, they are going to try to. You're not going to see the most extreme photos because remember there are prohibitions on showing jurors photos that could get you really, really upset. But I almost feel like she might. Well, maybe she won't, but I feel like she might take a plea on that before that case gets to trial. I feel like she's already heading up the road, but maybe not. Maybe she won't. I feel like sometimes when somebody's already convicted and heading away for life, sometimes they can be more amenable to working something out at that point. But we'll see. Yeah, I know that's good. Like I said, I mean, that's got to be a horrifying experience. I mean, it's almost it's like, you know, I've of course there have been cases where the court has actually provided jurors with like access to counseling after cases, because sometimes the things these jurors have to see sometimes, especially when it deals with young children, is so disturbing that it goes home with them. You know, and it really can impact people. But that is a reason why I believe you can ask to be taken to not be on the jury, if you believe stuff like that could cause you to not be able to be impartial. But yeah, it definitely is a rough situation with that. But anyways, guys. So with that said, I think we're going to go ahead and conclude it. It's 3:05 in the morning where I'm at, but I wanted to do episode 13. Like I said, as we will, the next episode, I promise, will be the Calvin Riley deposition of the police officer. We're going to be listening to that after we've already seen the body cam footage. And that should be very interesting. You as well, that one, girl. Thank you. I appreciate you coming in and saying hello and talking briefly here. But that will be the next one, I promise. Maybe we'll try to do it tomorrow night. Like I said, I'm going to try to work on getting the next episode out, episode 2 of the gag order. Also, those of you who are following the Treehouse case, a lot of documents were dropped on the 18th. So I guess that would be on Thursday by Ty Tucker. So head over there to the Monroe County Clerk's office. Transcripts of Roy Wilson's trial have been dropped. Various different motions and exhibits, all in support of his response to the motion in Lamine. So check it out. A lot of material was dropped over there. So go over there, check it out, read through those documents. We're going to definitely be covering it and going through some of them. Some of them, a lot, actually, pretty much all of them I have. But a lot of you might not have seen them yet. So go over there and check it out. Anyways, so we'll be covering that too, you know, on one of these episodes, and going in and looking at the exhibits. And hopefully the state will respond at some point here. They're going to have to within the next week or so, because they have, I believe, 10 days to respond. So we should be getting a response, I guess, what would that be? Maybe Wednesday. I think they're going to have a response in. So we'll see what that response has. And we'll see if any other motions are going to be filed, because I believe there's a pretrial hearing coming up. I believe it's in June. So we should be seeing motions start to get filed here by the state. Eventually, Mr. Tucker's going to be filing the motion to dismiss, I believe, and we'll see how all that goes. But anyways, guys, I appreciate you all. Thanks for watching tonight. I will see you soon. But until then, guys, let justice prevail, and we'll talk again soon. In the meantime, guys, jump over there to ko-fi.com, or I guess it's pronounced coffee.com, ko-fi.com. Follow that page so you're aware of all the happenings and things that are going on with the channel. All right, guys, till we talk again, let justice prevail, and I'll talk to you soon.